We simplify complex probate laws into everyday language. Today, we're tackling an important decision. Who gets to handle the estate when there's no will or when the will doesn't name an executor? Let's break it all down. Welcome back to our channel. California has a very clear structure for deciding who gets to be the personal representative when there's no will or when the executor can't or won't serve. It starts with the surviving spouse, but there's a twist. If the couple was in the middle of a divorce and living apart at the time of death, the spouse doesn't get top priority. They actually move down the list behind the decedent's siblings. Next up are the children, followed by grandchildren, and then other direct descendants. If none of them are available, the parents come into play. From there, it goes to siblings, including half-siblings, but not step-siblings. After siblings, it's nieces and nephews, and then grandparents, and so on down the line to aunts, uncles, and cousins. Now here's something many people don't realize. If there aren't any immediate family members or descendants, California looks to the family of any predeceased spouse. Don't you love that word, predeceased? To predecease someone is to die before they do. If tragically your goldfish dies one week and your gerbil passes away the following week, you can say the fish predeceases the gerbil. This could include their children or grandchildren, and even their siblings or parents. It's like a second chance to keep the estate within a broader family circle. And yes, it keeps going, eventually extending to more distant relatives on the predeceased spouse's side. This may seem unusual, but it's all about exhausting every familiar option before moving on to other possibilities. So what happens if there's no family at all, or if everyone eligible decides not to take on the role? That's when non-family options come into play. The court can appoint a public administrator, which is essentially a county official who steps in to manage estates when there's no one else. If that's not an option, creditors, yes, people the decedent owed money to, can petition to handle the estate. And if no creditors step up, and any other person can be considered. This might include friends, neighbors, or other non-relatives. But of course, the court has to approve them. Now let's say you have priority, but don't want the responsibility. That's okay. You can decline and nominate someone else to step in. For instance, if you're the decedent's child and feel overwhelmed by the idea of managing the estate, you can choose to nominate a sibling or even a professional like an attorney or a financial advisor. The process is pretty straightforward. There's no official form for this, but you'll need to write out your decision and attach it to the petition for probate. And if someone was named as executor of the will, but doesn't want to serve, they can also decline. However, they can't name a replacement unless the will specifically allows it. When you're ready to file the petition for probate, make sure you include all the necessary details you'll need to document. Everyone who has higher priority than you, and include written statements from them confirming that they've declined to serve. It's a crucial step to ensure the court process runs smoothly. Any missing or incomplete paperwork can cause delays, so it's worth double-checking. Double-check everything before filing. And who should get notice of the petition for probate? Remember these two words: intestate succession. It is the legal process of distributing assets and property when someone dies without a valid will. So all persons or entities, such as churches or other charities, named in the will, including each person or corporation nominated as executor, and all persons who would be entitled to inherit as heirs by intestate succession, even if the descendant left a will. are entitled to receive notice of the petition for probate. If a person's address is unknown, you must make a reasonable effort to locate the missing person and file a declaration or affidavit to tell the court what steps have been taken and who to notify. If a citizen of a foreign country dies without leaving a will or leaves a will that does not name an executor, or if it appears from the will that property will pass to a citizen of a foreign country, the notice must also be given to a recognized diplomat or consular official of the foreign country, if that official maintains an office in the United States. Notice must be given by first-class mail or by personally delivering a copy to each person or entity at least 15 days prior to the hearing. For each person should receive a copy of the notice of petition to administer estate, handling the hearing date information. It also is recommended, but not required, that each person be sent a copy of the petition for probate with all attachments. Beware, if you are the person who is asking to be appointed as personal representative, you cannot mail the copies, but must have someone else who is not a party mail the documents for you. After the copies have been mailed or delivered, have the person who mailed the documents complete the proof of service by mail on the reverse side of the notice of petition to administer estate and sign the proof of service by mail. Check to make sure that all the persons and entities listed on Attachment 8 of the petition for probate form have been given notice. If additional space is needed, attach a separate page. File the signed proof of service by mail with the court. Before we wrap it up, here's the big takeaway. Probate can be a detailed process, but understanding the rules of priority helps you navigate it with confidence. If you're facing a situation where family members decide who takes on this role, start by having open conversations. Clear communications can save a lot of time and prevent disputes later. And don't hesitate to get professional help if things get tricky. A probate attorney can make the process much smoother and ensure everything is handled correctly. Thanks for watching. If you found this video helpful, be sure to like, subscribe, and share it with others who might benefit. And if you have questions about probate or estate planning, let us know in the comments. We're here to help. See you in the next video. Disclaimer, the above information is intended for information purposes alone. It is not intended as legal advice. Please consult with counsel before taking any steps. Reliance on any of the information contained herein